Court of Appeals Division 1 is now in session.
Thanks. You may be seated. Do you have a sign-in sheet? Thank you. We are here today on our case number 1 CACV160035, Whitestone Shops at Pinnacle Peak, LLC versus Jade Palace, Inc. et al. Counsel, as you all know, the appellant's entitled, each side's allotted 20 minutes. The appellant may reserve any amount of time you'd like to use in reply. If you do decide to reserve time, though, you're in charge of keeping track of your own time, because the clock on the podium will reflect the total amount you have, including what you may have decided to reserve. We record these proceedings, so we'd be grateful to you if you, when you approach the podium, if you would give us your name and the name of your client. We have read the briefs, and we studied the record, the motion record and the trial record. We've also discussed the case in our conference together. So with that, Mr. Canfield, you may proceed.
Good afternoon. May it please the court. My name is Joseph Canfield. I'm here on behalf of the appellant, Whitestone Shops at Pinnacle Peak. With me today is my co-counsel, Penn Houston, and Doug Pine, in-house counsel for the Whitestone, and also Chase Bates, my associate. This case involves a commercial dispute between my client, who owns a shopping center, North Scottsdale, and the owner of an adjacent pad site to the shopping center. The dispute began when Jade Palace submitted plans to the Scottsdale Development Review Board to build a palatial 10,884 square foot restaurant well in excess of the 6,281 square feet specified in the parking agreement agreed to by the predecessor owners. To oppose this effort, my client incurred substantial expenses to stop that from happening at the City of Scottsdale before I'll call it the DRB for short, the Development Review Board, and ultimately had to bring this lawsuit to seek declaratory and injunctive relief and breach of contract in order to prevent that from happening. Now, although the appellee Jade Palace, who I'll refer to as Jade Palace, withdrew its 10,000 square foot restaurant submission, it did refile a second submission. Of course, this is all on the record. But the terms of that agreement, my client still believed violated the terms of the contracts governing the relationship between the two parties, which is both the parking agreement and the declaration, or CC&Rs, and I'll probably refer to them as either one throughout this argument.
Counsel, how did the second restaurant plan violate the parking agreement or the declaration?
Well, on appeal, Your Honor, we're on the second agreement. We're arguing that the court below erred in not permitting the question to go before the jury as to whether or not the second submission was reasonable in accordance with sections 2.1 and 2.3 of the declaration. That's a jury question. It's a reasonableness determination. And there was testimony presented, expert testimony from witnesses with tremendous credibility, experts in municipal matters, parking issues, and whatnot. And the question was whether that should have been answered by the jury, Your Honor, not.
How would you characterize this reasonableness argument? Would you characterize it as a claim? Is it a standalone claim? I mean, I'm trying to understand exactly if I have to label everything, but I didn't see anything about reasonableness in the complaint, and it seemed to evolve through the summary judgment process into the joint pretrial, and then in the form of a proposed verdict form.
Sure.
And so what exactly is the claim?
Breach of contract.
Okay.
To put it quite simply. So, and breach of contract was pled in count 4, both in the past, present, and future. And it was a was it specifically stated in the terms that ultimately ended up as the proposed question for the jury? Not precisely, but under the notice pleading standard, it was close enough. And as the case moved forward, it became clear that that was going to be a claim brought before the jury. It was in the pretrial statement. In the record on day one of the trial, there's an exchange between trial counsel and the judge where this argument was made by the appellee that, hey, you didn't precisely plead this, therefore you shouldn't be able to argue it. And the judge rejected that, said that this was, it was properly before the court. But that wasn't the reason that the judge refused to put the question before the jury. It was because he didn't believe that there was sufficient evidence presented to the jury that where a reasonable jury could have decided that the proposal of the restaurant proposal was unreasonable pursuant to the contract. And that's where we think the court erred under that standard, that no reasonable jury could have, hearing the evidence, decided that that proposal violated the terms of the declaration.
Well, what was the jury form that Whitestone, or what was the jury form that the judge ultimately gave to the jury in favor of your clients on that claim?
Declaratory judgment, Your Honor,
Okay.
on the first and second submission, and the question was limited to just the parking agreement. So it was as if the court refused to recognize that there are two contracts governing the relationship between these parties. And mind you, the second contract, the first one was entered into between the city of Scottsdale and the original landowner that owned the whole property before it was split. The second contract was entered into 5 years later, around the time of the split. So we believe that the second contract is, not that any contract is more important than another, but the second contract was extremely critical to the dispute that we have, which is the usage of that common parking lot.
So the second contract is would be the easement agreement, or the easement CC&Rs.
Yes, Your Honor.
And did the court not instruct the jury at all on that second contract?
That's correct. Yes, Your Honor. So the court only instructed, the question put before the jury, as I recall, was, first question was, did the first submission violate the parking agreement? The parking agreement, because the parking agreement had spelled out how large the footprint of this building could be. And so there was a question, under the objective numbers in the parking agreement. And then the second question was, did the second submission, which was smaller, but we still believe in violation of both agreements. Jury disagreed with us on the second, agreed with us on the first. And then, of course, the third question was whether the Jade Palace could use the parking lot to stage its construction. And none of those, we haven't appealed. Neither side appealed the jury verdicts. So that's not before. We disagree with the jury, but
The good thing for us.
Right. So we don't. But what we think, it's certainly reasonable for us to believe that the jury, having found that the 10,000 square foot restaurant violated the parking agreement, that it could also find that the 10,000 square foot submission breached the contract, these contracts. And we believe that the judge should erred on summary judgment in preventing that question from being.
But why would it be compelling? Why would there be a compelling reason to present, just take the two restaurants separately, the first submission, which was off the table? I mean, it had been off the table for quite some time by the time it got to the jury. Why would it have been appropriate for the trial judge to ask for any reasonable determination as to the 10,000 foot restaurant?
Well, Your Honor, he did ask that question with respect to the parking agreement, even though they had taken it off the table, so to speak. But we wanted, my client was concerned about future, was this going to come back again? There was arguments made during the trial that as long as the city approved any size building, a skyscraper, they could do it. Obviously, that was argument purposes, but it was quite concerning to our client. So we, at the end of the day, wanted an injunction. That's the third error. before the court was we think that even after the jury agreed with us that the 10,000 square foot submission violated the terms of the parking agreement, that the judge abused his discretion in not giving us an injunction to prevent them from doing that. So,
But what does a declaratory action, a judgment do? It in my simple thinking, it says you can't do this in the future. It doesn't say you did something wrong or you breached something. It doesn't say any. It just says, and I'm going to the back to the breach of contract. What exactly was breached?
well, Your Honor,
Because doesn't a breach necessarily imply a past act?
not necessarily. I mean, the case was pled as an anticipatory breach, so it could be.
I'm glad you raised that. I
Yes,
didn't see anticipatory breach at all in the opening brief. I could have missed it, but I didn't see any reference to it.
Yeah, I'm not sure how much we focused on it in the brief itself, but it's count 4, I believe, or it's either 3 or 4. Well, I can look at that for you. So I guess, Your Honor, I don't know if you're asking what the difference between a declaratory judgment action and an injunctive proceeding is, or or is it a declaratory judgment versus a breach of contract going to our first issue? I think maybe that's what you're asking. Is that?
It just seems like we're in a fairly strange situation here where, you're asking us to evaluate a motion for summary judgment, and the black letter law says we only look at the summary judgment pleadings before the court to determine whether there was a breach of contract stated. But then it seems like we're also bringing into the equation here the jury's verdict and sort of mixing, saying, well, this is what actually happened at the trial, so this could have affected, back at the summary judgment stage.
Well, I will concede to you that it's a little bit confusing based on the summary judgment briefing versus the judge's ruling that on issue 1. But that informs why we are so concerned and why we are asking for reversals, because there's a lot of arguments raised in the summary judgment. We didn't file it. This was filed by the appellee. There was, kind of standing ripeness kinds of claims, procedural claims and whatnot. But on the substantive question that's before the court, the judge said that I will deny the summary judgment. It was a partial summary judgment. I will allow summary judgment let me put this differently. I will deny summary judgment on the breach of contract claims because essentially that if you prevail on, meaning Whitestone, my client, on the declaratory judgment, then it's moot. But how can that be? I mean, they're two different things. The declaratory judgment, interpreting the rights of the parties with respect to the contract and a breach are different things, although it's pretty clear to us that the jury having found that the first submission was in violation of the agreement, that it was reasonable for us to believe and for a reasonable jury to conclude that they breached the contract. The very act of submitting that application to the city of Scottsdale is the first step in the process.
Question, isn't it? That's the question. Does the contract contain a covenant not to submit a site plan in violation of the size limit? Or does the contract, or is the covenant of the contract merely not to build a restaurant in violation of the size limits?
Well, Your Honor, I mean, the contract, we're talking about the parking agreement now, I assume. It's pretty clear.
Parking agreement, which really refers to the size of the restaurant.
Yes, correct. So that's the parking agreement is the one that's got all the numbers and what the footprint can be and the parking and all that stuff. The declaration's the easement saying we're going to share the parking lot and it's got to be a reasonable, sharing arrangement. So there's nothing that I can recall specifically that says that, but I think, under basic contract breach analysis, when did the breach occur? Well, we believe the moment that application was filed, they were in breach, and that we had to take steps to protect our rights. We tried to work this out. We tried to work this through with the Development Review Board. It was 2 months, if you look at the timeline, from the time that the application was filed before the lawsuit was filed, and it was 2 months after that when they submitted their second submission. So, that the breach, the wrong had occurred. We're simply seeking a remedy. Obviously, the breach of contract is a big deal for us because there's a serious question about damages, and that's a question that never got decided below because the judge said that the breach of contract claim was moot. He didn't say that there was no breach. He didn't say that. He just said it was moot because if we went on declaratory judgment, you never get to the question of breach of contract. And we think that's just wrong. It's a matter of law. And this court's de novo review can reverse that. We can go back and then we can argue the question of whether a breach of contract occurred and what the damages are. And that's issue number one. I think sorry, Your Honor, like you were about to ask me a question.
Go back to the reasonableness thing. I'm just struggling with how a jury might evaluate or determine, and I think the court was struggling with the same thing, how you determine potential future acts and try to say whether those are reasonable or not. I mean, it just seems like it's ripe for hypotheticals for you to say, well, this could happen. This 18-wheelers could be parked there all night. They could have.
Or they could have valets.
Yeah, they could have. They could have valets. They could have. I mean, they could minimize it with valets. They could have buses that come and bus people in. They could take every parking spot. Sure. Potentially. It just seems that there's so many what ifs and hypotheticals. Isn't that what the trial judge was getting at? And
yes.
Is that justifiable? Basically? Sorry
to interrupt you, Your Honor. Yes, I think that, and I'm sure you're going to hear more about that in about 2 minutes. And I would like to reserve a couple minutes for rebuttal. But I think fair question to ask, but we presented a case to show that the plan is submitted. The plan wasn't just a footprint and a number. It was a design. It was a restaurant that showed where the tabletops were going to be, that how they were going to use this patio. A lot of concern about the patio and whether that factored into the square footage. These days patios are an extension of restaurants, and the restaurant space that's used, and there was testimony in the record on this, is about 60% or so of the restaurant. But the patio, you get more restaurant usage if you think about it because you're putting nothing but tables out there. So we were quite concerned because what the testimony showed was that the design and the proposal was going to in fact bring upwards of 100 cars into that common parking lot, which was going to substantially and unreasonably burden my client and its tenants. And at the very least, Your Honor, that's a question that we think the jury should have been. The jury heard all this evidence, by the way, heard it all, but the judge wouldn't let the jury decide that question, and that's all we're asking. Is that you reverse that determination and let this go back and let the jury weigh that evidence and decide this question. So with that, unless there are any questions, I'll reserve the rest of my time.
Sure. Thanks. Mr. Jeans?
Good afternoon. First, I'd like to introduce, I'm Franklin Jeeds. I represent Davlin May and Jade Palace. Mr. and Mrs. May are here today. To see if I can do any good for them. Mrs. Ayers is with me. She is was a part of the trial team, and also Mr. Broadbent, who's the real brains in our outfit. So I'd like to introduce both of them. Well, the questions, I'm here mostly to answer questions. So if you have questions, stop me anytime. I would like to talk a little bit about a few of the things that were raised by Mr. Canfield. He has the unfortunate problem of not having been at the trial. Mrs. Ayers and I were throughout it, and Mr. Houston he was there as well. The question of this business of the declaration versus the, I think what I'd like to start is with the declaration. There's a tension between the request for declaratory relief and the request for damages under a breach of contract claim. I'd like to give you a little history of this in order to understand how that arose and how this transaction arose. And this is all on the record. And in fact, there's a very good, you have in your record the application of our response to the application of fees, and it has it's the best rendition of how this thing developed is actually in that document. It's kind of a strange place for it, but that's where it is. Anyway, Mr. May went to the city. He owned the lot. Whitestone had not yet bought the adjoining property to him. He went to the city. He asked him, how big a restaurant can I build on this pad? He was told that he could build a 9,200 square foot building. It would be first a restaurant on the bottom floor and then offices for this. He runs some other restaurants on the second floor. He then made an application for a 10,000 foot building. And remember that the city was a party to the parking agreement, so he thought that the city was the person that controlled the parking agreement. That's what his architect told him. He went ahead and made this application. Whitestone then purchased the property, or about that time purchased the property. They saw what he was doing. They came in and complained to the city before the design review board about this. And
Counsel, why would your client think that he could exceed the parking minimum, or the parking figure by over 3,000 square feet?
because the parking agreement was made at a time when the city had higher parking requirements. This all came out from Dan Heimer, who was the city's person on this during the trial. At the time that the original subdivision came, remember that the property all belonged to one person, and they wanted to get this balance between the parking for the whole center. The city at that time had a higher parking requirement, and therefore the property was underparked. In the intervening years, the city got more experience with its parking requirements, and it reduced the amount of parking that was required, so that by the time he went ahead and made application for this building, there was substantial parking under their regulations for parking a lot more cars for the entire center than there was at the time that this parking agreement was made. So the city told him to go ahead with the 9,200-foot application.
But regardless, the jury, based upon the jury's finding, the jury's verdict found that the first restaurant submission was in excess of the parking agreement.
Well,
How
Mr. May never went ahead with the 92.
And why is it? But why isn't it? At least for that time being, why wasn't that a valid breach of contract?
Because it was
Classic
not
breach of contract.
Because I've been in this court and I know what a valid anticipatory breach is. It's a total repudiation.
Well, let me ask you first: is anticipatory repudiation an issue before us?
No. That's the first issue, and it wasn't really raised in the case. But it is, I can tell you, this doesn't match an anticipatory repudiation because I lost that issue in this very courtroom. And so an anticipatory repudiation, I give you the cite for this, the case is a Monte Lucia case. It has to be a complete and total repudiation of the contract communicated to the party, to the opposing party.
Okay, so put that aside. What about regular breach of contract? Why
It
not?
can't be a regular breach of contract because there's no action taken to violate the contract. As you yourself pointed out, nothing has been built. There's no building there. And it was for that reason, going back to the trial, that the trial judge came to the conclusion there was insufficient evidence. Even if there was a reasonableness standard in the declaration, which the judge had found there wasn't, not a reasonableness standard that allowed Whitestone to control what May could build on his lot. It gave him the right to complain if he over abused the parking, but that wasn't what was before the court at the time. And it didn't give him the right under the law, as he read the contract, to complain about the size of the building. As they quote and we quote, the judge said, you can't control what Mr. May is going to build on that lot. What you can do is, if it later turns out that there's a parking problem, both parties can come to the court and we'll find a way to resolve it if they can't find a way to resolve it among themselves.
I'm just puzzled by the fact, why would the court allow the expert witness and numerous other witnesses, it appeared, to testify about how the parking would be affected, estimates as to parking, which that really had nothing to do with the up or down, the objective number in the parking agreement. Why did all that evidence come in?
I asked that same questions all through the trial.
But being...
And the answer was, under the skydive case, which we have which we have quoted in here, he didn't want to have any prejudice to the party from not being able to present their case. And in fact, that's what he
They
did.
presented their case, but then they weren't allowed a form of verdict consistent with the testimony.
Well, I understand.
Or do you disagree? I mean,
I don't disagree with that. I don't think that the testimony, and I said this throughout the trial, at the time, I didn't think that the testimony they were offering went to the issue that the court had presented to the parties to be tried, which was what is essentially there are two issues. One was the matter of the access for construction, but the other one was you had this 6,281 restriction. And the judge found that that was a valid restriction. The problem is it had plus or minus in front. And as the judge said, that doesn't mean 6,281 square feet. It means a range. What's the range? Plus or minus has to mean something. And he couldn't, in good faith, find that there was a legal answer to that question. And we actually looked for one, and there isn't. So he wanted the jury to give him guidance on what did 6,281 square feet mean. What they were saying is, later they came along and said, well, there's these reasonable standards, and the reasonable standards say that you can't build anything on that lot. It's zero. It's not only that 6,281 square feet is wrong, it's not only that 6,290 square feet is wrong, or 10,000 square feet is wrong. You can't build anything on that lot because it will cause congestion in the parking lot, and the parking will become a problem, and therefore you can't reasonably use your land because it's going to cause congestion on the parking in the parking lot. Well, it's a reciprocal joint use. Each party has a right to use the parking completely and reciprocally, and that's what the judge read. And I submit to you that there isn't any evidence in the record that goes to that issue, because the issue is what were the intent of the parties at the formation of the contract, and that wasn't what happened. But the judge went ahead and let them put their case on because I believe he was concerned that otherwise he would be said to have prejudiced them. Remember, it's not only that his instruction has to be in error, but there has to be prejudice. He didn't want to have any prejudice.
Tell us what the actual discussion on this issue is. Apparently not on the record at trial in some cases, at some points. So we're a little confused, frankly, as to the basis for the court's ultimate decision not to submit the question of reasonableness to the jury.
Well, I'll read you what the court said, because it took a long time, but it eventually came out what his concern was. And I'll address this is from the record of June the 10th.
Is that you don't get to decide?
Well, it's part of it. That's at the first. Later, at page 80, make sure I got the right page. At page 81, the court says, I think for two reasons. One is one is based on the evidence, and the other is based on the matter of law, that the requested verdict forms on reasonableness will not be given. One is that the declarations themselves don't give the plaintiff any right to impose restrictions on what is done on Pad A, that's the Jade Palace pad. And as a matter of fact, the evidence is purely speculative as to what the parking requirements will be of that building.
So on the former, the court's notion was the reasonableness contract, let's call it that, applies only to parking. It doesn't govern how big a space you're going to use, how big a building you're going to build. You can bust everyone in, and you're not going to infringe on anybody's parking rights.
That's correct. And the judge even used an example. Well, what if Mr. May got valet parking?
Yeah.
That was one example. But if you read, and I suggest the court go back and read carefully 2.1 and 2.3 of the declaration, what it goes to is the reasonable use of the easement, not the reasonable use of the property. May couldn't, as the judge pointed out, May couldn't go to Whitestone and say, I'm not getting to use enough parking because you've got too many people coming to the sole restaurant, which was open and running, nor can they go to May and say, you can't build your restaurant. Remember, the original site plan had a 6,280 plus or minus site on it, marked restaurant. And when Whitestone bought the property, that was there. It wasn't something that Mr. May dreamed up later. And so what the court said is, if you look at the declaration, it doesn't go to controlling the pads or the construction, it goes to controlling the parking.
When we talk about the square footage that is involved here, we talk about a breach of contract. You agree that 9,214 square feet was in excess of what was under the agreement, correct?
Yes, and that's exactly, Whitestone talks about that the jury found that the contract was violated. That isn't what the jury found. That wasn't what they were asked to find. What they were asked to find was, did 10,000 square feet exceed the amount that was set forth in the parking agreement?
And let's go back to what you said about breach of contract. You said they'd taken no action. I want to know from your perspective, they submitted their plans for a almost 10,000 square foot, let's say 9,500 square foot building to the city. That's an action, you would agree?
That's correct.
At which point does it become a breach of that contract that says 6,000 square feet, plus or minus?
Under my understanding of an actual breach, you'd have to get your permit from the city, and then you'd have to go start moving dirt. But we never got there, Your Honor. That's the worst part of this is we never got there because we withdrew. There was discussions between Whitestone and May, and Whitestone objected, and May said, well, will you agree if I just build a 6,280 square foot restaurant? They said yes. So he withdrew his application, and he refiled for a 6,280 square foot
And
building.
that happened over a period of what Mr. Canfield says is 4 months. So we have the submission, then we have the complaint filed 2 months later, then 2 months after that, it's the next submission, correct?
Yeah, I think it actually was a little shorter than that, but that's good enough for this purpose, yes.
Okay, at what point, you're saying you guys would have had to move dirt before they would have a cause of action for breach of contract?
Right, because we did not say to them, we're going to build this building, and you watch us do it, and then we do it. That isn't what happened. What happened is we made an application to the city. I mean, at what point, I suspect, would we have communicated to them directly that we don't intend to comply with what they say the parking agreement does? And that might have become an anticipatory breach. But the fact of the matter is we never did that. What we did was we said to them, if you don't like 10,000, we'll do 6,280. And that's what we then they amended their complaint to complain about 6,280, and later, during the course of development of the case, they added, and it's unreasonable to build any building there because it will negatively impact our future use of the parking area.
But they had to spend a bunch of money to get you to change, get your clients to change from 9,000 to 6,280. Why is that a breach of contract?
It's not
I mean, give me.
It's not damages in the first place.
Authority. What's the authority that there's no breach until that you pull a building permit?
There's authority. Well, there's no direct case on point. I have to tell you.
You have to admit that.
Yeah. I looked.
Okay.
She looked. He looked.
Okay.
They all looked. We looked. There's no direct point. They did probably too. There's no direct point. But what is true is the case law says in order to have an anticipatory breach, you've got to actually go to the person and repudiate the contract. And we never did that. In fact, when we found out, our client, when he found out that in fact they objected, he withdrew the application immediately. Now, and then they turned around and filed an application for 6,280.
Is that in fact what happened? That's what I'm a little bit hung up on, and I want to make sure I understand what happened. They filed requesting the permit. Then suit was filed. So they didn't immediately withdraw the application, or did they withdraw and then resubmit 2 months later? How does that occur? What's the series of events?
What happened was that in March, they filed for the 10,000 square foot building. They were then told, I don't know if they were contacted by Whitestone or they were told that Whitestone objected to the building. There was then communication between their lawyer and Whitestone's lawyer and Jade Palace's lawyer. And they came to an agreement, which is embodied in an email, saying if you'll reduce your building to the 6,280 square feet, we, Whitestone, will agree. There's some other things in it, but basically we'll go ahead and agree to allow you to, we won't complain that you're violating the parking agreement. May agreed to that, went ahead and proceeded to put a new application in for 6,000, withdrew the old one, put the 6,280 square foot application in. In the meantime, what he didn't know was Whitestone had been drafting a complaint on the 10,000 square foot building. They had filed that. They then amended it to go to complain about the 6,280 square foot building. That's the chain of events. Whether it was over 2 months, in my memory, it was like we weren't quite involved. We'd heard about this, but it was somewhere around 3 months. But that I don't know for sure.
Thank you.
I think you're right. I think that email says, let us know in a week if you agree to reduce the size of your restaurant, and apparently Jade didn't get back to them within a week, and 2 days later the complaint was filed.
Something like that. But they had told them, their lawyer, and Brian Jordan is the lawyer that represented Whitestone at the time, was told that they would go ahead and do it. And in fact, they did do it. They withdrew their old application and put in a 6,280 square foot application.
Is the fact that the prior application was withdrawn, is that in evidence? Is that a fact in evidence?
I think it is, yeah. I don't think there's any dispute about the fact that the prior application was withdrawn.
Okay.
And I've blown most of my time, so I thank you very much. Any further questions?
Thank you.
Thank you very much.
Are you asking to use his time?
I was just teasing him. He has another minute. I've got a couple of minutes, Your Honors. Just a few things I wanted to address, or any other questions you might have. My client, Whitestone's not trying to tell Jade Palace how to run its business. I mean, this is about a reasonable use of the common parking lot, and it's a fair question whether the manner in which they proposed to use that restaurant was going to violate the easement, sections 2.1 and really 2.3, because that says you can't use it in a way that's going to impair the business interests of either side. They could have easily brought the same claim against us if we were going to do something that they thought was going to burden the parking arrangement. And the breach, Your Honors, it did occur when this application was submitted. That's when it happened. That's how you start the process. If we had an agreement and there was an historical structure on the property and we agreement not to demolish that, if they filed for a permit with the city to demolish it, that's when the breach occurs. We don't have to wait for the wrecking ball to hit the building in order for that to happen. And that's essentially what they're arguing, is when we should have waited till shovel hit dirt, and that's just not correct.
So, Mr. Canfield, why wasn't that breach cured when they withdrew the application and resubmitted the smaller building application that complied with the square footage requirements in your documents?
Well, because, Your Honor, we still don't believe that even the second submission complied. I mean, like I said, there was a question about the patio, and we obviously would like that question to be answered. Well, the jury disagreed with us with respect to the square footage in the parking agreement itself, whether the patio itself should be included in the footprint or not. But we think it's it is a question of reasonableness for the jury to decide whether even the second submission violates the declaration on reasonableness. Because I think the judge below, as best I can tell, it can come to the conclusion at some point that if you complied with the parking agreement, then reasonableness there was reasonableness under the declaration. And we just don't understand that. We think that's a separate agreement, separate question. So even if there was compliance with the parking agreement, which we don't believe there was, it's still a legitimate question to ask, a jury question, whether or not it was a reasonable proposed use of the property as as they submitted to the city. So we would ask that, and I think, Your Honors, you asked some questions about, well, why did, the judge allow the presentation of evidence on reasonableness only then to not put the question before the jury? And we have been wondering the same thing. And that I'm sure the jury heard a lot of stuff that they were confused about when they were in the jury room. Well, why did we hear about this, and why did we hear, from the former city manager of Scottsdale, who's an expert on this kind of parking situation, and not ever to have a question related to that. So they easily could have answered the question. So it wasn't judicial economy that was the reason for that.
But what would have been the argument that your client would have made on that question to the jury? What would have passed muster under the easement in your client's view? Well,
what the testimony showed was that this was going to bring at least 100 or so additional cars. Obviously, some percentage of that was okay, but 100 was too much, and we would have shown, and we did show through expert testimony. I know I keep saying that, but that we really did have a great expert who talked about this, and the jury could have weighed that. But it was going to be more. We also had testimony from one of the existing restaurant owners, who was concerned. We had testimony from Whitestone personnel who know these property the situation of that particular corner and the demands upon it during peak seasons, and this is going to create a problem. I mean, that was pretty clear. The only question was whether the agreement didn't prohibit that from happening. So I see my time is up here. So.
Do you have any more questions?
One last.
You certainly may.
You've used words like the building of the restaurant was going to result in unreasonable use of the parking lot. Your experts showed that it would. Everything you've said is speculative regarding reasonableness. When we judge reasonableness, is there any way to know, other than my expert said so, what's actually going to happen? I mean...
Well, Your Honor, and that's... all we're asking is that the jury decide that question. Is as they proposed, and one thing I didn't hit on was the city is very mechanical or mathematical about how they decide parking. It's just a rote formula of square footage divided by some numerator and denominator. But it's what our people looked at, and what the jury heard the testimony on was, given the way they submitted the plans, it was, it's basically tabletops. I don't know how it's more simple to put it, is that, you could see on the plans how many people were going to be, that restaurant could serve, on both inside the restaurant and on the patio. And then from that, you could figure out, based on peak season and times, the late evenings are busier than other times. And then from that, they could say, well, this is going to, bring upwards of 100, 150 people in at times, and then you divide that by a number resulting in 95 to 100 or so additional vehicles, and then you get to the burden when you look at the contract. So that's it. I know, Your Honor, it sounds speculative, but that there was definitely, the jury could decide whether or not that this was going to happen, and whether there was a serious risk of anticipatory breach. As we talked about, you hit on that a little bit. My understanding of that law is there has to be a material breach that's and a positive and unequivocal statement of intent to breach, and I think the application itself gives us that. So, unless there are any further questions, I'll.
Thank you.
Thank you.
Thanks to all the lawyers for your argument and for your briefing. We're grateful to you for your time.
Thank you, Your Honor.
Thank you. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.